Hi, and welcome to Holland Estates. You're listening to episode number 633. I'm Stuart Clark,
I'm Fred Tonelli.
and welcome. Hello, Fred.
Hey, Stuart, how are you doing?
Good, thank you. Good to be chatting with you today and podcasting with you today. This month, so when we're recording this right now, it's still February technically, and I think this will be released while we're still in the month of February. And this month at Holland Hall in our blog series, we've been featuring kind of an overview structure of charity law, just kind of talking about charities generally and how it interplays into the estates and trusts world. And so we thought today it might be a good idea just to take it back to, we'll call it Charity Law 101, and just chat about at its most basic what a charity is, and try to continue that discussion thread that we've been having in our blog series this month. I'll start us off basically saying at its most basic, a charity is a trust. And that's kind of why we in this estates and trust world kind of, sometimes dabble, we'll call it, in the charity world as well. Because at its most basic, a charity is a trust, and it has to adhere to the same general requirements that any trust does. And so those are what we call the three certainties, right? I mean, if you're a lawyer and think back to your first trust law class, or if you're a client who has a trust, you've probably been told that a trust has to have what is called the three certainties. And they are: one, certainty of intention. It must be clear that the settlor intended to create a trust. Seems pretty basic. Number two, certainty of subject matter. It must be clear what assets are to form part of the trust. And three, certainty of objects. It must be clear who has an interest in the trust. Now, in the case of a charity, it's given kind of special rules or considerations for the three certainties with the third one, which is certainty of objects, right? The one where it says it has to be clear who has an interest in this trust. So in the context of a normal trust, the idea that you have to know who a potential beneficiary of a trust is there so that, you can know, one, if you're the trustee, who do you have to make distributions to, or who could you make distributions to? But then to reverse that, it also has to be clear who potentially can bring a claim against the trustee to kind of keep them honest, right? Who could in theory, request an accounting? Who can say, hey, wait a second, I think you've done something wrong with this trust. I think you've created a breach of trust, and I want to hold you to account or keep you honest for the administration of the trust. So that makes sense for the normal trust. But in a charity, you kind of think, well, wait a second, if I create an animal charity, are the animals supposed to sue me? Who is it that, how do I know who the potential beneficiaries of this trust charity are, and how do they keep me accountable? So for certainty of objects at a charity, they're kind of given special consideration because you're right, the animals aren't going to hold you to account. We don't know if it's for the relief of poverty, if you're creating a charity to help people who are a food bank, for example. Well, how do you know who a potential recipient of a food bank is? It could be anyone, right? That's the whole kind of the concept, is it for the betterment of the community. So when you have a charitable trust, the historic rules have turned a little bit or changed a little bit for a certainty of objects. And it says that in that instance, you're allowed to uphold the three certainties so long as your trust has what's called a charitable purpose. And what a charitable purpose is dates way back for history, but also is defined by case law. And I think Fred will chat a little bit more about that now.
Sure, thanks, Stuart. That was very good and very helpful. So in terms of defining what a charitable purpose is, the original definition comes from a 1601 law passed under the reign of Queen Elizabeth I of England, and that is the Charitable Uses Act. And the language has changed. Obviously, the language at that time was the language of Shakespeare and a bit different than our current modern English. However, the four factors that have been considered to be charitable purposes in the Act are: one, the relief of poverty; two, the advancement of education; three, the advancement of religion; and four, other purposes beneficial to the community. Now, the first three are fairly clear. Obviously, there would be some wiggle room as to what education and religion might be in certain contexts. But the idea of purposes beneficial to community is where one might have some wiggle room, because it can be somewhat vague, and also there is room for interpretation. For example, Stuart, I believe you said you had a case recently that there was something about what benefits the community that was actually determined by the Supreme Court not to be something benefiting the community involving a soccer club, if I'm not mistaken, correct?
Yeah, no, exactly. I kind of both love and hate the fact that we still base what is a charitable purpose and therefore what is a charity off of this statute that goes back to the time of Queen Elizabeth and Shakespeare in 1601. And you're exactly right. There was a case, I mean, I say recent, 2007, but it was a case, in relative legal terms, at least by 1601 standards, relatively recently, from the Supreme Court in Canada, called AYSA, Amateur Youth Soccer Association versus Canada Revenue Agency. And the citation there is 2007 SCC 42. And in that instance, it's exactly what you said there, Fred. So a youth soccer club, if everyone could picture what a youth soccer club or youth soccer association is like, lots of little kids playing soccer, promoting soccer, sport, et cetera, et cetera. Well, they applied to CRA saying, well, we think we meet the definition of a charity and that we should get the benefits of what a charity has, tax purposes and also just, existence, governance purposes, because we think we fit under the fourth heading, which Fred talked about, which is other purposes beneficial to the community. So obviously the basic argument there is, well, look, we're promoting sport, we're promoting health, we're helping get, the community, healthier. We think that we are a purpose beneficial to the community and therefore we should meet the charitable definition. CRA said, nice try. No, we don't think you meet that definition going back to 1601. They appeal and they get all the way up to the Supreme Court of Canada. And surprisingly enough, the Supreme Court agreed with CRA and said, nope, the promotion of sport is not a public benefit, quote unquote. And in coming to that conclusion, they kind of say, I'm quoting here from the thing, basically paraphrasing that while it's accepted that participating in sport is generally beneficial to the community, these benefits alone are not enough to qualify an organization as a charity. And basically, the case law supports that sport, if ancillary to another recognized charitable purpose, like education, can be a charity, but sport in itself is not a charitable purpose. And this kind of helps you swing back around and say, look, the charity law is old, right? I mean, I can't think in my head of another statute that we still use that goes back to 1601. But at its most basic, if it wasn't a charity in the time of Shakespeare, you're going to have a hard time saying it's a charity now. And you can, debate the merits of whether or not you think sport should or should not be a charity. But it's interesting that we still kind of rely on these old statutes. And I love the fact. So I actually, recently kind of, because I mean, now, with time and with cases from 2007 Supreme Court, the language has been modernized a bit from 1601. I mean, I'm sure if anyone's ever tried to read Shakespeare, you kind of know what ye-olde language we're dealing with here. But I mean, like, if you read the actual original act, it includes charitable purposes like, the marriages of poor maids. I mean, I don't think, if I don't think in 2022, I imagine CRA is not encouraging them, or thinking that a public benefit is marriages of poor maids, but I guess who knows? But it's interesting that we still rely on these old statutes to get there. But yeah, so I mean, so that is a charitable. So if you can hit one of those four, headings for what a charitable purpose is, you then can get that certainty of objects exception, saying, okay, fine, we're going to let you now be a charity, and your trust is created, and hey presto, have a charity. Now, obviously, it's more complicated than that. If you were planning to start a charity, I would encourage you to go and talk to, a lawyer and make sure everything is done properly, because there's a whole other, governance questions to have. But at its most basic, I mean, charity law dates back to, I'm sure it dates back to before Queen Elizabeth, but our current incarnation of charity law dates back to Queen Elizabeth I in 1601, and we are but a continuation of that.
To that point, Stuart, when I was taking trust law course in law school, we actually had a whole lecture and chapter in the textbook devoted to the history of trust law, because it is actually one of the more history-heavy areas of the law, because it had changed through the equitable courts and through statutes of Queen Elizabeth and the Stuart monarchs as well. So it is interesting how this is one of the areas of law that has a very long history in which old statutes from 400 years ago still apply.
Yeah, no, exactly right. I mean, I'm sure if any lawyers out there listening only need to be told the words, the rule against perpetuities, which is a fun part of trust law and estates law that you need to worry about to kind of get a shiver up your spine. Yeah, we're dealing with old areas of law here, and actually interesting. So for on the point of rule against perpetuities, one of the benefits if you do qualify as a charitable trust. So for those in normal trust circumstances, the rule against perpetuities basically means that they're trying to stop your trust existing forever. They're trying to stop a scenario that we had back in medieval England, where rich lords and ladies would set up these trusts that would then control family wealth and money through generations, hundreds of years. So the rule against perpetuities basically means your trust can't run forever. And it stands for proposition that all assets in the trust, so any money, property, etc., has to vest and be distributed within the lifetime of someone alive on the date the trust was created, plus 21 years. So basically, you're talking the longest a trust could exist. So let's assume someone lives a long life. Someone lives 90 years. So if you say, okay, we're going to base this on person X and they were born on the day of the trust, live 90 years, and then the trust has to be distributed by 111 years from the creation, because the person alive plus 21 years, 90 plus 21 gets you to 111. My math's right there. So if you're a charity, you're saying, oh, wait a second, does that mean that if I'm set up a trust for food bank or OSPCA, that every 100 years I need to fully distribute every asset that's in this trust and start again from scratch? Well, if the rule against perpetuity is applied to you, the answer would be yes, you would. But luckily, if you are found to be a charitable trust, you get an exception to the rule against perpetuities, and you can, in theory, exist forever. So therefore, you don't have to worry if you're a charity. Okay, well, shoot, do I have to backtrack? If you're the Salvation Army or something, and you're created in 1822 or something, I don't know when I created, but do you have to restart yourself every lifetime plus 21 years? Well, no, you don't, so long as you meet a charitable purpose. But if you're a soccer club and you're trying to be a trust, you probably do.
Exactly.
Interesting enough. Well, I think this was a great topic. I mean, I think it's always useful to kind of take a step back and think about foundational 101 principles of just what the heck, what is this? What is a charity? Well, charity is a trust, and if you know what a trust is, you can usually figure out what a charity is, and it kind of helps you figure out, if you're trying to, work through a problem with a charity, it helps to kind of go back to basics. I think that probably brings us to the end of our charity law 101 discussion today. It's been a pleasure podcasting with you, Fred.
You too, Stuart.
And again, if anyone has any questions, please feel free to email us at info@hollandhall.com or leave us a comment on our website. Thank you again. I'm Stuart Clark.
I'm Fred Tonelli.
Bye-bye.